So if you're wondering, how do I get these intellectual property copyright protections? The answer is that once you fix it into a medium, a tangible medium, you have automatic copyright protections. So they exist as soon as you fix them into a tangible medium. So that means that the work is either recorded and documented, so it's on paper, you know, or it is in some other means, whether it be recorded or digitally stored or otherwise documented somewhere. So some key points about automatic copyright protections: originality. So the work must be original, meaning that it's independently created and not copied from another source. It must be it has to possess a minimal degree of creativity. And the fixation, again, it has to be in a tangible medium. So it has to be in a book, a manuscript, a recorded song, a digital file, or a physical sculpture. And again, you check those boxes and then you automatically get the reproduction rights, right to distribute copies of the work, right to publicly perform or display the work, and the right to create derivative works based on the original. There are limitations to the automatic copyright protection, specifically if disputes arise over the infringement of the ownership. So in this instance, having your work registered with the U.S. Copyright Office can provide additional legal benefits that are not available with the automatic protection. So for example, one of the more important reasons to register your work is that the registration is a prerequisite for filing a lawsuit for copyright infringement. In the United States, if someone infringes on your copyright, you cannot take legal action against them until your work is registered. So what this means is that if your work is unregistered and you discover infringement, you're going to have to register it first before you can file a lawsuit. If you register your work within 3 months of publication or before an infringement occurs, it allows you to seek statutory damages and attorney's fees in a lawsuit. So those can range anywhere from $750 to $30,000 per work infringed, and it can go up to $150,000 if the infringement is willful. Without registration, you may only be able to recover the actual damages and the profits, which can be much harder to prove and often result in lower compensation. So if you want to get fully what you're owed, you're going to have to register it in order to do that. The other benefits is that it establishes a public record of ownership. So in this case, it helps in the dispute of the ownership. It serves as evidence that you are the original creator of the work, making it easier to prove ownership if the other party also claims the same work. Basically the burden of proof shifts. You have this clear-cut documented federal registration that says that this is yours and you did it 3 years ago or something. So, now that it's an issue, you can refer to said registration. So basically, if you register the work within 5 years of publication, your registration is considered prima facie evidence of the validity of the copyright and the facts stated in the certificate, such as the date of creation and ownership. So the presumption automatically becomes, in these legal disputes, the presumption becomes that it's yours. And so, like I said, it shifts the burden of proof on the defendant. It's like, well, this person has this federal document that says that it is theirs and it's from 5 years ago. And now you're coming forward and saying that it's yours. Where is your proof? And so they have to provide it. So it makes it harder for them to win the case. So that's something to consider. So if you're thinking about registering federally, again, you are not required to do so, but you would have to, you'd want to prepare, you'd want to have whatever your work is. So whether it be a digital file, a manuscript, a recording, an image, because you will have to register a copy of that work in order to get the copyright, the formal copyright. Information about the work, so you have the title, the date of creation, and any publication details. And then information about the author or authors and the copyright claimant if it happens to be different from the author. Now, I go one step further. Since I operate under an LLC, my copyright is going to the LLC, and I'm a work for hire under the LLC. So that's kind of how it works. Maybe a little bit of additional protections there for me personally. But again, that's just depends on how cautious you want to be out there. So you'd have to create an account with the U.S. Copyright Office, complete your online registration form, pay the registration fee, usually like $45 for a single work. I think I paid $65 for two. And then once you've paid your fee, then you will have to submit your work to them. So you can be submitted, it could be a PDF, it could be a JPEG if it's an image, etc. It will just depend on the nature of the work, on what you present to them. And then you will receive your certificate for registration. So registration of the copyright is not required, gives you extra protections if you do it. I think you just need to think about your needs and your risks and determine whether or not you think you should file one or not. I have formal copyrights on some work and not on others. It just depends on how you feel about it and how far you want to take it. So, and how many protections that you want. So it really is a case-by-case basis, a person-by-person basis. You are granted the automatic copyright protections, but if you want the additional protections, I would advise that you register with the U.S. Copyright Office, but it's not required.